Hello, and welcome to this news event hosted by the Public Investors Advocate Bar Association, or PIABA for short. You'll be hearing from three speakers today, and then we will open the floor for questions during the Q&A period. The Q&A period will be for reporters only, and if you wish to ask a question, use the raise your hand function and your line will be unmuted when it's your turn to ask a question. For more info and to follow along with today's news event, go to piaba.org where you can find a news release and report, and we'll also be dropping a direct link into the Zoom chat box here shortly. As I mentioned, you'll be hearing from three speakers today. First, PIABA President-elect Michael Edmiston. Second, former PIABA President and report author Hugh Berkson. And third, current PIABA President and report co-author David Meyer. So let's go ahead and begin with our first speaker, PIABA President-elect Michael Edmiston.
Thank you very much. My name is Michael Edmiston. I'm a securities arbitration and litigation attorney based in Los Angeles, California. I'm the PIABA Executive Vice President and President-elect. The Public Investors Advocate Bar Association is an international, not-for-profit voluntary bar association of lawyers who represent investors in securities and commodities arbitration and litigation. PIABA's mission is to promote the interests of the public investor by seeking to protect such investors from abuses in the arbitration process, make securities arbitration and dispute resolution as just and fair as systematically possible, and educate investors concerning their rights. PIABA is currently celebrating its 30th anniversary. Just as the securities industry has evolved, so has PIABA and its members. Having grown from just a few attorneys spread across the United States, it now has almost 400 members representing investors in litigation, arbitration, and mediation, as well as participating in regulatory rulemaking and legislative efforts to improve investor protections and dispute resolution throughout the United States. As a result of the expansion, PIABA has recently changed its name from Public Investors Arbitration Bar Association to Public Investors Advocate Bar Association to more fully describe the efforts of its members on behalf of investors. Thank you for joining us today discussing FINRA's unpaid arbitration award problem.
Thank you, Michael. Again, that was PIABA President-elect Michael Edmiston. So let's go to our second speaker, former PIABA President and report co-author Hugh Berkson. Go ahead, Hugh.
Thank you. Good afternoon for people on the East Coast, morning for everyone else. I'm Hugh Berkson. I'm a principal with the law firm of McCarthy, Levitt, Crystal, and Liftman in Cleveland, Ohio. The majority of my work is as an arbitration attorney on behalf of investors. I'm a former president of the Public Investors Advocate Bar Association, a current member of our board of directors, and one of the co-authors of the Unpaid Arbitration Award report that's being issued today. So let's start with a little background. Prior to 2016, the only entities tracking unpaid arbitration awards were the U.S. General Accounting Office and the Wall Street Journal. First, the GAO issued a report 21 years ago covering the 1998 fiscal year. It found that nearly 50% of investor arbitration awards went unpaid. Second, the Wall Street Journal found in 2013 that 11% of arbitration awards went unpaid in 2011. Something didn't add up. That's why, in 2016, we at PIABA decided we needed to do something to address the issue. We took a look at the raw data from posted arbitration awards on the FINRA website and found that nearly 1 out of 3 arbitration awards went unpaid. That totaled over $62 million of unpaid awards in 2013. The 2016 report issued by PIABA included our first public recommendation that FINRA created an investor recovery pool as a remedy to fix the unpaid award issue. The FINRA CEO at the time, Richard Ketchum, in testimony to Congress, acknowledged the findings in the report were problematic, and he went so far as to indicate that FINRA would work with the SEC on the issue. He also indicated that he could see FINRA instituting an investor recovery pool. Here we are 5 years later, and not much has changed. The new report being issued today finds that nearly 30% of investor awards in FINRA arbitration proceedings went unpaid in 2020. And further, 24% of all money awarded in arbitration in 2020 has not been paid. COVID had no effect on this. While there were fewer cases and fewer awards in 2020, as you'd expect, the percentages of unpaid cases remained in the same ballpark as the pre-pandemic experience. There's a caveat. Please note that the 2020 figures are slightly worse than 2019's, in which FINRA found that 27% of total awards went unpaid and 19% of total dollars awarded that year went unpaid. The problem isn't getting any better, despite the fact that 2020 saw stable or record high profits for the brokerage industry. Making matters even worse, the arbitration awards that went unpaid significantly understate the problem because investors and their arbitration lawyers routinely do not bring cases where they know there's no chance of getting paid. And that's a real defect in the system. If the system's going to work, aggrieved investors should have a right to be heard and paid. My colleague, David Meyer, will get into this in just a few moments. But how do we fix the issue? The report offers several remedies. Number one, a legislative remedy. While FINRA can solve the problem directly by instituting a national investor recovery pool, it has refused to do so unless ordered by the SEC or Congress. So long as FINRA continues its refusal to institute an investor recovery pool, absent an instruction from Congress or the SEC, then PIABA asks Congress to intervene and address the problem in order for FINRA to do its job to protect investors. We all know how well the legislative process is working these days, so we offer remedy number two, an SEC Dodd-Frank remedy. If Congress cannot or will not act, FINRA maintains course. The SEC has the authority to step in under Section 921 of the Dodd-Frank Act. They could require, as a condition of firms requiring a mandatory arbitration clause in their customer agreements, that firms participate in an investor recovery pool. So, the National Investor Recovery Pool. It would provide recovery funds for investors who pursue a claim all the way through a final award and have exhausted reasonable efforts to collect the award from the respondent. There are a variety of potential sources for funding, including FINRA fine monies assessed against member firms and associated persons who violate FINRA rules. 2, assessments on FINRA members. 3, fees levied on the investing public. Of each option, creating a national investor recovery pool presents the most viable option because it can be created within the existing regulatory structure and will present both the lowest financial impact to the brokerage industry and the best financial impact for aggrieved investors. So, we have a very clear problem the industry created and a very clear way it can be fixed and financed by the industry. So in closing, I'd like to leave you with a final thought. If there was a goal to protect people from suffering devastating injuries, would it be best to install seatbelts before the car accident or after? Investors today have no seatbelt against unscrupulous stockbrokers, investment advisors, and firms that handle hundreds of millions of customer dollars without sufficient capital reserves or liability insurance. And what happens if there's a significant market downturn, exposing hundreds, not thousands, of fraudulent schemes perpetrated against a population retiring at record rates who have relied on their 401ks to fund their retirement? The potential harm is catastrophic. We must act now, and we must solve the problem before it gets any further out of hand. I'll leave it at that. And that concludes my opening statement. I look forward to questions. Thanks.
Thank you, Hugh. Again, that was former PIABA president and report author, Hugh Berkson. That takes us to our third and final speaker today, current PIABA president and report co-author, David Meyer.
Hello, everybody. Thanks for joining us. Again, my name is David Meyer. I'm with the law firm of Meyer Wilson based in Columbus, Ohio. I'm a securities arbitration lawyer, and I'm the current president of PIABA and a co-author of this report. And I want to spend a couple of minutes just putting a face and a name to all the numbers and statistics that are so compelling in the report that we're issuing today. And I want to describe a current case that I'm handling on behalf of a retired widow who entrusted her life savings with an investment advisor. And after having lost a significant portion of her life savings with that advisor, she had the strength and the conviction to hire a lawyer, pursue her legal rights. She went through the entire mandatory arbitration process. She went through a full hearing. We had a 3-day evidentiary hearing. She obtains an award in her favor for the full amount. She then goes to court to get it confirmed. And now at this point, she faces the real likelihood that she will be stuck with an unpaid arbitration award. Her name is Barbara Gelderlos. She lives in Columbus, Ohio. She's 74 years old. She is a strong, independent individual who spent 40 years working at Ohio State University, taking care of her family, especially focused on her husband as he battled brain cancer for nearly 20 years. She and her now deceased husband entrusted their entire life savings with a local investment advisory firm called Fisher Wealth Management. Mr. Gelderlos and her husband believed that since the firm was fully licensed to manage customer assets, they were completely comfortable and felt safe that the company was able to properly manage their life savings. And as her husband was literally dying from brain cancer, the advisor sold them hundreds of thousands of dollars of totally speculative, non-public, illiquid private securities. They lost $600,000. And at the urging of her trusted advisors, she found the strength to hire a lawyer and pursue her claims through the arbitration process. We went through the whole process for a year. She participated in the 3-day arbitration hearing, which obviously caused her a lot of pain and uncomfortable experiences she had to relive. She went through all that. In May, she got a full award by the arbitrator for $612,000. We got the court to confirm the award earlier this month, and now it's a small firm, and she faces the real possibility of not collecting on her award. And she faces the reality now of that she'll never see the money that she's lawfully owed, even after going through the legal process, doing everything she was supposed to do. And she never would have imagined that going through this whole ordeal, that the financial planning firm that was supposed to be the expert in financial matters would not have the financial ability to satisfy a judgment, or that there was no requirement for insurance in the industry, or that there was no regulatory protection to ensure that she would collect a judgment from a fully licensed registered investment advisory firm. This problem has been going on too long, and there are many, many people like Ms. Gelderlos who are faced with the unpaid arbitration problem. It's time for a fix, and the time is now. So thank you for your time, and I'm happy to answer any questions as well. Thank you.
Thanks, David. Again, that was current PIABA president, report co-author, David Meyer. And that takes us to the Q&A portion of the event. So if you wish to ask a question, please use the raise your hand function. Your line will be unmuted when it's your turn to ask your question. And as a reminder, the Q&A period is for reporters only. If you happen to be having issues with your own audio or the raise your hand function, you may use the text-based Q&A box, and we'll do our best to get to all of those questions. And before I begin, I want to mention that a video recording of this news event is going to be available online later today on the PIABA website, along with the other media materials. So that's piaba.org. And it looks like we've got some questions queuing up. So let's go ahead and take our first question from Tracy Longo at Financial Advisor Magazine. Tracy, go ahead and unmute yourself. If possible. Let's see.
Here we go.
Perfect. Thank you, Tracy.
Thank you. Thank you for having this presser today. I always enjoy what you folks have to say. I'm wondering what the latest tenor from FINRA, if you have met with or talked to any of the officials or the CEO there, and gotten a feel if anything has changed, or there's an opening for some kind of policy coming out of FINRA with regard to fixing this.
My understanding, and then I'll let Mike or Dave weigh in, is FINRA has instituted a number of rule changes that would discourage bad actors from remaining on the field and making sure that firms who hire them are under stricter scrutiny. They're trying to shrink the number of people who can create the problem, but they're not addressing the problem itself. Dave?
Yeah, I agree with that. I think these incremental changes will help, on the ends, but it's not going to have a significant impact on the huge unpaid arbitration award. We gotta fix the problem as opposed to just addressing the symptoms.
I had a quick follow-up. Thank you both. Dave, could you spell the name of your client and restate the firm?
Yeah, the firm is based in Columbus, Ohio, called Fisher Wealth Management, and it's Miss Gelderloos, Gelderloos, Gelderloos.
Okay, very good. Thank you.
Thanks, Tracy.
Right. And let's go ahead and proceed to our next question. It's going to be coming from Mark Schaaf, Jr., Investment News. And Mark, please unmute yourself.
Hi, everyone. Thanks for holding the this presser and taking my question. First, I want to confirm your answer just now to Tracy's question. You were referring to this to the FINRA rule on brokerages with a history of violations in firms that hire a large percentage of brokers with a history of violation. That's what you say is not going to be effective because the capital requirement in that rule could be used to fund unpaid arbitration awards.
Mark, I think it's a step in the right direction. It will not, however, address the entire issue. To my understanding, it is not feasible to raise capital requirements sufficient that in the absence of any sort of insurance, these firms have enough capital reserves to ensure that anytime they're found liable for wrongdoing, the reserves are sufficient to pay the awards. Again, it's a step in the right direction, but it's not a fix.
Right. And then one other quick question, if I could. In terms of a legislative fix, Democrats now control both chambers of Congress, albeit barely. What's the outlook for a legislative fix right now?
I think the short answer is extremely poor based on what's going on now in DC. The reality is the practical way to resolve this problem is through the SEC at this point.
That doesn't mean we won't call on Congress to act. We will. But being realistic, the odds of that going through are low. Not nothing, but low.
Okay, thank you.
Okay. And we do want to make sure that all the reporters on the line have a chance to pose their questions. So again, if you missed the prompt before, if you do have a question to ask, use the raise your hand function and we'll unmute you when it's your turn to ask a question. And as a reminder, Q&A is for reporters only. And if you have any issues with your own audio or the raise your hand function itself, you can use the text-based Q&A box. And we'll do our best to get to all those questions. And it does look like we've got a Q&A box question. I'll go ahead and read it. The question reads, why does the industry have such a high rate of unpaid arbitration awards? Don't these firms have professional liability insurance coverage for these claims?
That's actually a great two questions. I'll answer the second one. I can't think of a single client that sat across my desk or on the other side of a phone who didn't express great surprise that their broker or investment advisor had no insurance. The fact of the matter is there is no requirement from FINRA or the SEC to maintain liability insurance for these folks. Some states have started to change that for registered investment advisors, but generally speaking, there's no requirement, and so many work with no safety net whatsoever.
Okay.
Which is sort of ironic when you think that these firms are pitching to their clients, you need to hire me because I will help you be fiscally responsible. But when I'm called to task, I may or may not be fiscally responsible myself.
Okay, thank you. So I don't see any more raised hands. Oh, I spoke too soon. It looks like we have a follow-up from Tracy Longo at Financial Advisor Magazine. So I'll go ahead and unmute Tracy. Go ahead, Tracy.
I'll be a pain. Would you say most of your most of the folks that you're going after in arbitration are registered investment advisors, or are they registered investment advisor reps or brokers, or and would you say they're mostly state registered or SEC registered? I'm just curious if you have a anecdotal feel.
So Tracy, I think it's fair to say that this problem, goes over all of them. I mean, there's definitely cases against brokerage firms where we see this problem, but with the rise of the business and the investment advisory world, we're certainly seeing more and more. But I think it's distributed equally between broker dealers and investment advisory firms, and then on the IA side. My case I just mentioned happened to be a state regulated, but I think it's still split equally between the state regulated and the SEC. I mean, 10 years ago, 15 years ago, I think most of our cases were, 90% BD cases. It's probably 50-50 now, but the unpaid arbitration world, our unpaid arbitration world encompasses all of it. The problem is it's much easier now to track the unpaid arbitration world in the FINRA world because that information is available publicly, but there's no centralized database to track the unpaid arbitration awards in the IA space, which makes this problem, it's even worse than we can report it because there's no centralized place to search those.
Thank you very much.
I'm
sorry, go ahead.
That, to follow up on what Dave said, the data shows that the number of claims being made against investment advisors is on par with the number of claims being made against brokers. But to Dave's point, there is no centralized database either at the state level or at the federal level that would let us analyze the exact scope of the problem. And that's actually one of the calls to action within the report, is asking the SEC for federally registered investment advisors to start reporting that sort of information and a database be created so that that data can be analyzed.
Great, thank you. I'm just checking for more questions. I know there are several reporters on the line, but I also know that some folks prefer to do their questions offline. So just in closing, we want to make sure you know where to get more information following today's news conference. To connect with any of the speakers that you've heard from today, or just to get more info, you can contact Alex Frank, 703-276-3264, or at afrank@hastingsgroup.com. And as a reminder, a recording of this news event and all the related media materials are going to be available online today at PIABA.org. So about to close, but do any of the speakers have any final thoughts that they want to share before we end this news conference?
Just want to thank everyone for taking the time to participate and read the report. Thank you.
All right. Well,
I'll echo Dave's sentiments. Thank you all for the time you've spent on this. This is an issue near and dear to my heart and PIABA's interest, and it's an issue that we look forward to continuing to work on until there's a solution on behalf of investors.
Great. Well, thanks to all of our speakers and our attendees. We appreciate you joining this news event hosted by PIABA.